All right, everybody, welcome back to the Learning Out Loud podcast. I'm your host, Dustin William. I have my co-host with me, Whitestone.
It is undeniable that a vast proportion of the actual doctrines and rules which make up the system of equity are necessarily inferences from or direct applications of some or more of these fundamental maxims.
The power is neutral. It's sitting in the quintessence until you invoke it. Behind using these things are good and holy and Christ-like.
I shall now attempt to show how the most important of these principia have been crystallized into the pithy form of maxims and have influenced and developed that grand system of truth known as equity jurisprudence.
Welcome everybody back to the Learning Out Loud podcast. I am your host, Dustin William, owner and producer at True Life Productions. You can find all of our content at truelifeproduction.com. Where you can start out by checking out All Aboard. That is where I do deep dives on New York in the 1850s, and in particular the orphan trains. And by the time this episode comes out, I will probably have a couple of episodes of my new supplemental series to that, The Hidden Origins of the Orphan Trains, where we get very meticulous about everything that was happening before the trains happened, which is very important context to understand about why the trains happen. But from there, you can head to Article 3, Articulations, where I have the most comprehensive breakdown of the slaughterhouse cases there is on the internet. A lot of spicy stuff in there, really good breakdown. You will not be confused by what that decision says by the time you leave. And from there, you can head to the Thought Chiron Dojo, where you can watch my research as it happens. I just revamped the whole thing. It's a lot easier to navigate, and it's got all of my research. All of my research is much easier to navigate, where you can navigate the grammar portion of it before I put it into my brains for the logic portion of my research. But that's enough for the business. Let's get right into it and introduce our co-host, Whitestone. How's it going, man?
I'm doing pretty good. Looking forward to getting into this one. I think I might say this about everyone, but really every maxim contains a piece of the crux of equity, which is, basically the golden rule.
Yeah. Yep. Do unto others as you would have them do unto you. And this maxim, he who comes to equity, or he who seeks equity must do equity. This is actually pretty closely connected with the last show that we did, which is he who comes to equity must come with clean hands, otherwise known as the clean hand doctrine. That's what it'll be in like legalese terms. But this show is going to go hand in hand with that. Pretty much these two maxims are closely connected, as you will see as we go through it. But before we get there today, I actually wanted to share something that I just found very interesting, that I found doing my Bible study this morning. And before I get into the verse I want to break down, I want to read a little bit of the last paragraph of the Declaration of Independence. This is a very important document. This is actually the document that gave us our independence. It's not the Constitution. This is the one that freed us from Britain. As you will see, they solemnly publish and declare their sovereignty from Britain. So I'm just going to read this verbatim into the record first. It says, "We, therefore, the representatives of the United States of America in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions," very strong word in equity, "do in the name and by authority of the good people of these colonies, solemnly publish and declare." That's the part I really want to emphasize. Solemnly publish and declare that these united colonies are and of right ought to be free and independent states. That they be absolved from all allegiances from the British crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved. More equity language there if you're reading it right. Uh, but that's all I want to read into the record for now. But like I said, I want to emphasize the solemnly publish and declare part. And then I want to head here to the 1560 uh, Geneva Bible. And it's kind of hard to read here, but this is Isaiah 52:7 from the 1560 Geneva Bible. And this is the Bible that Calvin and everyone wrote for the Protestant Reformation. This is when they broke away from the Catholic Church and they wrote this Bible for the Protestant Reformation. So this is Isaiah 52:7 from the 1560 Geneva Bible. How beautiful upon the mountains are the fate of him that declareth and publisheth peace, that declareth good things and publisheth salvation, saying unto Zion, thy God reigneth. Okay. There's like I said before, I want to emphasize the publish and declare part. So we're going to go back and then we're going to head to the 1611 Bible and we're going to read, how beautiful upon the mountains are the feet of him that bringeth good things, that publisheth peace and bringeth good and bringeth good tidings of good, that publisheth salvation, that saith unto Zion, thy God reign. So, did you catch which word's missing there, Whitestone?
Between the Geneva Bible and this one, let's see, how beautiful upon the mountains are the fate of him that bringeth good tidings. Some of the part about declaring is not in there.
Right. Right. Isn't that interesting?
Yeah, interesting. Go back to the 1560 version real quick.
Yeah.
That declareth and publish. Yeah, so they took declareth out.
Yeah. Declareth and publish. And then it says it twice. The that declareth good tidings and publish salutation.
But in the version after that,
The
it
1611
say
version, which is they took the
publish.
1560 Bible and kind of
Yeah, they basically just took out declareth because it still says public or basically
yes,
publish.
right. It still says publish, but it doesn't say declare, which, as we know, in equity, declare is a very important word.
Right. I mean, it's when you declare something as a matter of fact.
Yeah, so you can publish something and it doesn't have to be a matter of fact, but if you publish and declare it, just like they did in the Declaration
Right.
of Independence.
It's interesting that that's in the 1611 version, but the Declaration of Independence was, what, a little more than 150 years later. So somebody had the old Bible.
Right, so somebody, yeah, which tells me they're probably, a lot of them are probably going off this Geneva Bible. Because,
Interesting.
yeah, yeah, same thing in the KJV. Afterwards, the word declare is missing. So, yeah, interesting little catch I
Hey,
found
let
this
me
morning.
I'm sorry, what scripture is that? Isaiah 52:7?
52:7. Yep.
Okay, I
Wh-
just happen to have the Masonic Bible in front of me. Let me look
Oh,
at it.
nice. Yeah, let's check that out for sure. Which 52:7 is two sevens, by the way, if you're into numerology. 7 7.
Oh, yes, it is.
Yeah.
Okay, so let's see. We're gonna go to 52:7. I forgot Isaiah's one of the bigger chapters.
Yeah, it's a bigger book. Yep. Sandwiched in between a bunch of little ones too, actually.
All right, so let's see. The book of Isaiah 52:7. How beautiful upon the mountains are the feet of him that bringeth good tidings, that publisheth peace, good tidings, or that bringeth good tidings of good, that publisheth salvation, that saith unto Zion, thy God reigneth. So it's not in there either.
Uh-uh. Interesting.
Right. And I had heard many times before that the Geneva Bible was the one that was used for a lot of the original writings, if I'm not mistaken.
Yeah, I am of that opinion. And it's the Geneva Bible is the one that they put in all the margins and stuff. Basically, the king has no authority, God has all the authority. And that's why the
Right.
Catholic Church hated it.
Well, they couldn't fight it. I mean, they can't deny you your right to publish and declare anything.
Right, right. So they just got to take it out of the book you're reading. That'll tell you to do it.
Yeah, the book that they allow to be in your hands. They're like, well,
Yeah.
we're just gonna take that out.
Yep. Yeah. Yeah. So
Crazy.
that's interesting. Yeah. The Geneva Bible. That's basically why the Jesuits were formed. Was to fight the Protestant Reformation.
Right, because I think the Jesuits were accepted or inducted into if I'm saying it right, into the Roman papacy, or basically into the Vatican at 1540, because I think it was 1534 that Loyola had started the Jesuits, and 6 years later, I think it was 1540 they got let in.
Yeah. It was yeah something around that time. I can't remember the exact timeline right now, but yeah, yeah. It was definitely before 1560, and they
Yeah.
started specifically to combat the Protestant Reformation.
Yep, 100%. And that's in
Yeah.
a lot of the Jesuitical oaths and everything else that they're going to go forth into the lands of Christendom and basically paint the walls with Protestants.
Yep.
So,
Yeah, that's fucking crazy. Yeah, but yeah, that's just the facts, Jack. So
yeah.
yeah. So that just gives me even more validity to everything that I study, that they took that word out. Just gives me
You
all
know
the
what?
more
It's
reason to
interesting
declare
to
everything.
me, and this is just me thinking out loud kind of question. If the Vatican and the Jesuit order views Protestantism as kind of as like the enemy or the target, then wouldn't anybody claiming to be Protestant or having Protestant writings be looked at suspiciously as like an enemy, rebel, and belligerent?
Probably. Yeah. Yeah,
Yeah,
I would
because
imagine.
even if you're on the at-law side as a Protestant, I mean, you're still opening yourself up if you're not trying to get into an exclusive equity or an equitable
Hmm.
result.
Yeah, yeah, which yeah, who even knows what any of these words mean anymore?
Yeah, that's
You know.
yeah.
But yeah, 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 it was yeah, but that's all I wanted to touch on that. I just thought it was super interesting that they took that specific word out of that specific passage.
It's almost, I wonder if it's a way of telling you as well, hey, boys and girls, this used to be in the Bible.
I mean, yeah, yeah, I that's why I look to the Bible to for everything. That's why I'm reading the story of the story of redemption in the Bible right now, and it just happens to be that guess how many stories of redemption there are in the Bible?
Oh, there's dozens.
33.
Ah, so not quite 3 dozen, but
Not quite 3 dozen, but yeah, yep, 33 of them.
wow.
Yep. Isn't that interesting? That's how many I came up with anyways. There might be more, but that's how many I found. So,
I was in an antique store yesterday in a small town across state, and I found it was a modern reprint, but it was the 400th anniversary edition of the Geneva Bible, and I
oh,
think it was like
nice.
I was either 1590 or 1609 or something like that, somewhere
Mm,
around there. But they wanted $200 for it, so I decided to live without it.
damn, that sucks.
Yeah.
I know. That's this finding this morning. You can get nice Geneva Bibles off of eBay. Really nice bound ones and stuff. No, with it they enlarge the print and everything to make it easier. Stuff like
Oh,
that. So
really?
yeah, yeah, I'm gonna order one
Eh,
off of eBay. They're only like $80 too for a new bound one.
it's not bad.
Yeah. Yeah, for sure. All right. Yeah. So yeah, that's all I wanted to hit on that. We can move on to what we've been talking about for the last 5 episodes. We're gonna get back to Murray F. Tully's speech to the bar in 1903, all about the 20 maxims of equity. Excuse me, everybody. I've been sick forever. Hopefully I can make it through this. Um, So here we are at maxim number 5. He who seeks equity must do equity. Um, and like I said before, this maxim is closely associated with the last maxim that we hit last week, which was he who comes to equity must come with clean hands. But you'll see that as we go further on in the episode. So, you want to start us out reading this time, Whitestone?
Yep, can do.
Perfect.
All right, so number five, he who seeks equity must do equity. All the authors give it in this form, except Francis, who has it, quote, he that will have equity done to him must do it to the same person. There's the golden rule.
Hmm.
The meaning of this maxim is that the court will give to the complainant the relief to which he is entitled on the condition only that he has given or is ready to give the defendant such corresponding rights as he may be entitled to in respect to the subject matter of the suit. So there's a balance in equities there.
Hmm.
Whatever may be the nature of the relief sought by the bill, the equitable rights of the defendant growing out of or intimately connected with the subject matter of the action will be protected. Nothing will prevent the application of this rule, except the intervention of the principle of the maxim that he that doeth iniquity shall not have equity, as illustrated in the Illinois case where the party had improved the land wrongfully and fraudulently withheld by him from the owner. An illustration of this maxim is found where a borrower of money on usurious interest comes into a court of equity to set aside the transaction, or asking the cancellation of the usurious contract. He can only have relief upon the terms of returning the money borrowed with lawful interest as the equity of the defendant who loaned the money. To have the money with lawful interest is as great as that of the borrower to be relieved from his unjust obligation to pay the usurious rate.
Um, who's talking? Max was found to borrow money. Okay, yeah, so he was talking about usury there. I missed that part. Sort of is found where a borrower of money on usurious interest comes into a court of equity. Actually, I think one of the cases we're going to talk about later, it is that's basically what it's over is a contract that's charging a boatload of interest, and these people come into court trying to seek equity to get out of the contract, but it's not how it works,
Yeah.
unfortunately. Um,
But I think what this here was saying is basically if equity steps in on a contract where there's usury and the claimant claims, hey, this interest rate is ridiculous, they'll basically say that you are responsible for the money that you have borrowed and lawful interest, but anything above that they're going to void. Is that
See, well, as we'll learn in the case later, that is what they say. But if the state has laws against usury, then it can void the contract.
right? Right.
So, yeah, it depends on which state you're in, I would say. Because actually, well, in the case we're going to read, one of the cases we're going to read today, the Supreme Court actually does still respect states' rights in that respect, anyways, in the equity side of it. Um, unless you got anything else, I'll start.
No, let's keep moving.
Perfect. Moving right along, another striking illustration of the maxim is where the husband, under the Old English law, came into equity for the purpose of getting in his wife's equitable property. The court would not give him its assistance except upon the terms of his making a reasonable settlement upon his wife. This was commonly called a wife's equity, and the rule of the maxim was first applied in the class of cases. This equity of the wife, termed the wife's equity, was the first innovation made upon the law of England, which treated the wife as the one having no rights of property which her husband was bound to respect. It was the first innovation upon the English law, which vested in the husband the absolute ownership of all personal property possessed by the wife, or to which she might become entitled during coverture, even her own earnings, and also the absolute right to receive for his own use all the rents and profits of her real estate. The more I'm reading equity too, I would, I don't even know. I don't think I know any female creators in the equity space, but I imagine it's a completely different read for a woman because there's a whole different, like, especially in like marriage laws and stuff like this, it's a whole different ball game. Like women have, uh, uh, I don't, in England, it like he's saying here is like they basically didn't have any whites rights. And in American equity, we innovated on that and gave the woman some rights.
Yeah, we
Um,
basically made them beneficiaries of anything that they would have been a part of. Because if I'm not mistaken, a lot of the marriage arrangements up to and somewhat during, but mostly before women's lib kicked off, many here, because here's the thing, is before then, they say women didn't have rights, but with that came that didn't have liabilities either. So if
exactly.
their husband had massive amounts of debt and had creditors coming after him and he passed, or he ended up becoming completely insolvent, his wife was not responsible for any of that because she
Hmm.
was in more of like a beneficiary status. And so I do think that reading Equity for Women would be different, when it comes to looking at some of these Supreme Court cases when it says, the man is basically grantor trustee of all of the property, and the wife basically holds an extremely limited sort of beneficial interest in the estate. Because I've seen that in other cases as well, where basically like in the marriage contract itself, uh, when they talk about divorce, the wife already has a predetermined sort of severance package or beneficial equitable interest that they have a stake in for the duration of the marriage, or whatever it is.
Yeah, there's almost like a prenuptial agreement in like a trust form, kind of.
Right. And it was more like, when you wanted to marry a woman, or you and a woman wanted to get married, that I think sometimes it seems that there was like an endowment or like a dower that was paid by
Hmm.
one family to the wife of the or to the family of the wife. And
Yep.
then once you pay that dower, then she comes over and you get married, and she has a beneficial equitable interest in the estate that's managed by the husband, wherein she has no liability.
Yeah, and the more I read this stuff, it almost seems like before there was marriage licenses and shit, it almost seems like this is how they did it, was through trust.
Yeah, because I think you're right. I think the license, because now, a license is for, permission to do something. And if
Exactly.
you're a, a sole corporation and you want to do business with another corporation, you got to have some sort of license for some sort of merger
And
of, some sort
that's
of
it.
merger of property into, something called community property, and there's tax benefits and all involved. You got to get a license because you're getting
Yeah.
benefits and privileges.
You're paying for the right to do commerce with your wife.
Yes.
That's what you're doing when you get a marriage
Yeah.
license.
And I think that, there's a lot of, and I'm not to get off the rails, but
Yeah.
there's a lot of people, men and women that are included, that understand equity, that look at a lot of these older forms. It goes, if anything goes to court, everybody, as long as they have clean hands, walks away getting exactly what they want and exactly what they agreed on,
Yeah.
instead of getting dragged through the family courts and the divorce courts and things of that nature.
Instead of telling the state, hey, would you like a right to my property that you didn't have before we signed this license? That's basically all you're doing when you sign a marriage license. You're saying, hey, state, would you like to be able to take my shit? So
Yeah.
it's
So because
not to shit
I've
on
thought about
anybody that's married, but I mean, when you break it down to its most logical terms, that's basically what you're asking.
Yeah, and I know every once in a while you hear the media chirp about a particular celebrity that made his girlfriend sign a contract and this, that, and
Hmm.
the other, and or whatever. And it's like, I guarantee it's because their attorneys or whoever else understands this stuff.
100%. Yeah, they just ain't no
You know?
dummies, then you just don't
Yeah.
understand what they're
I mean,
doing.
if you're worth, $25 million and you want to get married, it's like for asset protection and for equitable interest. This is how a lot of them do get married. They don't necessarily get married under marriages and license agreements.
No, no. I mean, some of them might do it how they used to. They might just write it in the Bible and make a trust. And then,
Yeah.
I'd imagine I would, that's how I'm going to do it.
I mean, if you're worth $25 million and you end up getting served divorce papers, are you going to want to go to the at law side and fight that?
Absolutely not, because they are going to ream
Absolutely
you.
not.
They're going to ream you
Wasn't it
dry.
even like Bill Cosby? I think it was I think it was Bill Cosby. Um, or it might have been OJ, or it might have been both of them, that when they had to pay up, they still retired and were on golf courses and just living a luxurious life because like 95% of their net worth was held in trust.
Yep.
And on the civil side, they only lost a couple pennies, so they're like, yeah, whatever.
No, whatever. Yeah, because they wasn't no dummy.
Yep. No dummy.
They wasn't no dummy. Yep.
I
All
love
right.
the jello into equity. Anyway, sorry.
Nice. Nice. Nailed it. All right. Let's
All right. Yeah, sorry.
moving right along. It was the first great step in the emancipation of women from the pitiable and selfish bondage in which she was held by the laws and customs of England. From the beginning, the Court of Equity has been the consistent friend and advocate of the rights of women, so far as the rights of property were concerned. Its persistent efforts to have her equitable rights in her own property and large protected and conserved is one of the brightest chapters in the history of equity jurisprudence. This maxim stands out in full force in all cases of equitable estoppel. At common law, a man might stand by and see another person by mistake build a house upon his land and afterwards bring ejectment for and recover both house and land, but equity interposes and says such conduct is against conscience. You shall only be allowed to recover possession of the land and house by making compensation for the building which you knowingly permitted the party to put thereon under a mistake, thinking he was building upon his own land. Um,
Well, that's kind of a sly way to get at somebody where they think they're building on their land and you know that it's yours, but you let them build a house anyway, and then later file in or put in a bill for an ejectment and take back the house and the land that they built.
yeah, yeah, that's kind of yeah, it's a little snake in the grass move right there for sure.
Yeah, equity's like, yeah, no, you can get the
Yeah.
land back, but you either have to help him take his house apart and tell him to build it somewhere else, or it's like if you take it, you got to compensate him.
But you know what? At law, you can 100% do that.
Yep.
Say, see you later, buddy. And there's nothing you can do about it. That's the crazy thing about the at law part. The at law part basically works like with houses and stuff and mortgages. It basically works how old English equity used to work, but they
Yep.
definitely refined it and made it a lot better in America. Um, yeah, I think that's all I got for that section though.
Okay, great. All right. So, next paragraph. In the specific performance of contracts, the application of this maxim compels the party seeking relief to comply with all the conditions and agreements upon his part. I can't read through that stamp.
Now, it all comes into play in cases where equity would compel and
And
of course this stamped around
yeah, so I got that stamp right over it. Would
compel
compel
an eviction
an
between
action, would compel an action between two,
yeah,
no.
yeah, inconsistent gifts.
Between
Yep.
two inconsistent gifts or donations, and in cases where one creditor has a lien or security upon two funds and another has a subsequent lien on only one of them, the holder of the security on the two funds will be compelled to shape his own remedy so as to preserve, if possible, the equity of the one whose lien extends to but one fund.
Hmm.
And that's actually, very similar to one of the cases we're going to be reading today, where there's multiple creditors on this one corporation. And one of the, I think one of the creditors that basically had the primary and priority right got in there, and the Court of Equity told them that you got to make sure that all the other creditors get what they justly deserve as well, or something
Hmm.
along those lines.
Yeah, something along those lines. Yeah, it was pretty interesting.
So reading on, the principle of the maxim underlies to a large extent the whole theory and jurisdiction of equity in respect to the marshaling of assets. In one chancery cases, there was what at this day would be called an extreme application of the rule of this maxim, considering the imperfect report which we have of the case, but I am not prepared to say that the rule was then improperly applied. The complainant had obtained of defendant £4,000 secured by mortgage. After the execution of the mortgage, he obtained £2,000 more, but not put into the mortgage. He paid £1,500 on the £4,000 and filed his bill to redeem from the balance the £4,000 mortgage. ruled that if the complainant would redeem, he must reimburse the defendant for all, that is, for the balance of the 4,000 and also the 2,000. For that he that will have equity to help him when the law cannot shall do equity to the same party against whom he seeks to be released in equity. The principle of this maxim has also been applied to cases where a party applies for relief against a note or security invalid by law, and the party holding the same was not guilty of any intention to violate the law, the court holding that the party should have the equitable relief of delivery up or cancellation only on paying what was justly due in the transaction in which the same was given. And then it cites the case Dean versus Robinson and Cowan v. Roger. It would seem that this just principle must permeate the whole administration of equitable relief, as it is not possible to conceive of a case where it would be equity to grant the complainant relief and deny to the defendant equity in regard to the same transaction. The rule of this maxim is, therefore, necessarily enforced in all cases of conflicting equity.
Mhm. Yeah, I like how we ended on that too, because actually I think it might be the first case we're going to talk about. I can't remember but it's actually the defendant who gets to enforce the equity in the case,
Yeah,
which I thought was really
because
interesting.
sometimes there are situations where an appellant or a claimant, or a plaintiff, whoever is alleging that they are owed a debt, and the defendant can also say, well, yes, they owe up to and including this point. However, I also have my equity over here that the court has to be cognizable of and recognize, and they'll grant it. As
Hmm.
long as it's equitable.
Yep. 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 Yeah, I thought that was really interesting, and I had never actually thought about equity in those terms, even though one of the people we follow, he talks about that as you can win as a defendant as long as you know
Yeah,
how to work the equities.
absolutely. As long as you know what your rights, duties, privileges, immunities, and things like that are. I mean,
Hmm. Yep. Yep, absolutely. All right. That does it for Tully's speech for today, though. We're zipping right through that thing. I think what we're on page 30, something like that. Yeah, page 30. Paragraph two, six of them down, or five of them down. Um, and today we're gonna go. So that was a little short section, so we are gonna go into a little bit of Pomeroy. Um, of course, because he's always, he's I see him cited more than anybody else in in all of the equity cases, even more than Story. Story gets cited a lot, but even like the more modern cases, they're definitely citing Pomeroy more. Um, so yeah, unless you got anything to add, I guess we'll probably just read section 385 right into the record.
yeah, I'm fine with that. I've got my copy here as well.
Okay, cool. Yeah, I was gonna ask you because there is one section where a couple of the words are cut off on my copy, so I might have to have you read it. Um, but okay, yeah, we'll go ahead. This is section 385 from John Norton Pomeroy's Equity Jurisprudence Volume 1, and I'm pretty sure it's the fifth edition, almost positive. So,
You're using the fifth edition?
pretty sure. Yeah.
Okay.
It's either the fourth or fifth. I can't remember. I'll have to
Do you
check
know
on it.
what year? Do you know what year that came out?
1905 or 1906, I'm pretty sure. Something like
Really?
that. Yeah. Or maybe is
Because
that the fourth edition?
I think because I've got the third edition and it's 1905.
Mm. Maybe it's the fourth from 1906 then.
Could
Because
be. Yeah.
I'm pretty sure it's 1906 that this one was printed. No. Anyways, section 385, it should be the same in both of them. So, and uh this is its meaning, and he's talking about the maxim, he who seeks equity must do equity. So its meaning. This maxim expresses the governing principle that every action of a court of equity in determining rights and awarding remedies must be in accordance with conscience and good faith. In its broadest sense, it may be regarded as the foundation of all equity, as the source of every doctrine and rule of equity jurisprudence. Since it is undeniable that courts of equity do not recognize and protect the equitable rights of the litigant parties unless such rights are in pursuance of the settled judicial notions of morality based upon conscience and good faith. But as a practical principle guiding the equity courts in their administration of justice, the maxim is only used in as much narrower and more special meaning. Even in this narrow significance, it is a principle of most extensive application. It may be applied, in fact, in every kind of litigation and to every species of remedy. The meaning is that whatever may be the nature of controversy between two definite parties and whatever the nature of the remedy demands, the court will not confer its equitable relief upon the party seeking its interposition and aid unless he has acknowledged and conceded or will admit and provide for all equitable rights, claims, and demands justly belonging to the adversary party. And growing out of the necessarily and growing out of or necessarily involved in the subject matter of the controversy. It says, in effect, that the court will give the plaintiff the relief to which he is entitled only upon condition that he has given or consents to give the defendant such corresponding rights as he also may be entitled to in respect of the subject matter of the suit. This meaning of the principle was more definitely expressed by an eminent judge in the following terms. The court of equity refuses its aid to give to the plaintiff what the law would give him in the courts of common law had jurisdiction to enforce it, without imposing upon him conditions which the court considers he ought to comply with, although the subject of the condition should be one which the court would not otherwise enforce. In this narrow and particular sense, the principle becomes a universal rule governing the courts of equity in administering all kinds of equitable relief in any controversy where its application may be necessary to work out complete justice. That is a pretty big definition, but I do like that definition. This is something you talk about a lot too, is that doing equity is a lot of different things. And what he says in here, the meaning is that whatever the nature of the controversy be between two definite parties, and whatever be the nature of the remedy demanded, the court will not confer its equitable relief upon the party seeking interposition and aid unless he has acknowledged and conceded or will admit to prove and for all the equitable rights, claims, demands justly belonging to the adversary parties. That basically what he means there is you had better just clean your side of the street. You had better, and do your equity, which is, a lot of it is giving notice, doing, service of process. Basically, whatever the situation demands for is what he's talking about here, that's what doing equity is. And you have to do it on your side as well as the other, as if whether you're the defendant or the plaintiff, as well as the other side having to do as well.
Yeah, it really is that, you get two people in front of a judge and they're going to decide, where the equitable rights lie. And part of getting equity is acknowledging that the other side also might have a valid claim against you that you're going to have to be okay with. Like let's say
Mm-hmm.
go in and you've got nine obligations from this, from whoever the defendant is that you're asking for enforcement on. But that defendant will say, yeah, but I've got one obligation, from you that I'm demanding. And so you have to acknowledge it's like, you're right, I've got one thing that I need to do from them, but they still owe me the nine. And
Mm-hmm.
that's saying it's like, look, they do have a right. They do have a right to that one thing, but that doesn't change the fact that they owe me, A through H or whatever it is.
Yeah, absolutely, absolutely, and I like that about equity because at law, that's not how it's going to happen. You have one winner, one loser, takes all. Fucking Roman, fucking gladiator shit.
Yeah, it's Battleship,
Yeah, yeah,
Yep, there's only one person winning,
yeah.
one person
Military
standing.
battleship to be more specific, but
Yep,
yeah.
absolutely.
Um, yeah, I like that little section of Pomeroy there. That's a good little explanation of what doing doing equity is. And oh yeah, the footnote. What did I read? Want to read out of the footnote?
Yeah, a lot of these footnotes, I would say that when the footnote takes up more than a page, 2 pages, 3 pages, you definitely need to read it.
Yeah, there was obviously something good in here. Do you want to read this one?
386 or the footnote.
The footnote. I got it up on the screen right now.
Okay, yeah, I can do it.
Perfect.
So this footnote is somewhat lengthy, so settle in. All right, so this footnote was given after what Dustin just read. In the two following quotations, this aspect of the principle is stated in the most accurate manner. Hansen v. Keating per Wigram. The argument in this case for the defendant was founded upon the well-established rule of this court that a plaintiff who would have equity must do equity, a rule by which, properly understood, it is at all times satisfactory to me to be bound. But it is a rule which, as it was used in the argument of this case, takes for granted the whole question in dispute. The rule, as I have often had occasion to observe, cannot per se decide what terms the court should impose upon the plaintiff as to the price of the decree it gives him. It decides in the abstract that the court, giving the plaintiff the relief to which he is entitled, will do so only upon the terms of his submitting to give the defendant such corresponding rights, if
Mhm.
any, as he also may be entitled to in respect of the subject matter of the suit. What those rights are must be determined aliunde by strict rules of law, meaning, of course, rules of equity, not of common law, and not by any arbitrary determination of the court. The rule, in short, merely raises the question what those terms, if any, should be. If, for example, a plaintiff seeks an account against the defendant, the court will require the plaintiff to do equity by submitting himself to account in the same matter in which he asks an account, the reason of which is that the court does not take accounts partially and perhaps ineffectually, but requires that the whole subject be, once for all, settled between the parties.
Get that
Clark,
full
Clark
accounting.
yeah, full accounting. And they're
Yeah.
going to say, well, in order for us to properly understand their books and their accounts and what you're asking, we're going to need to see the corresponding work on your side to make sure everything matches.
Mm-hmm. Mm-hmm.
So, and it quotes Clark v. Tipping. It is only, I may observe as a general rule, to the one matter which is the subject of a given suit that the rule applies, and not to distinct matters pending between the same parties. So, in the case of a bill for specific performance, the court will give the purchaser his conveyance, provided he will fulfill his part of the contract by paying the purchase money, and e converso, if the vendor were plaintiff, the court will assist him only upon condition of his doing equity by conveying to the purchaser the subject of the contract upon receiving the purchase money. In this, as in the former case, the court will execute the matter which is the subject of the suit wholly and not partially. And it continues. So if a bill be filed by the obliger in a usurious bond to be relieved against it,
Oh,
the
sorry.
court, in a proper case, will cancel the bond, but only upon the terms of the obliger refunding to the obligee the money actually advanced. The reasoning is analogous to that in the previous cases. The equity of the obliger is to have the entire transaction rescinded. The court will do this so as to remit both parties to their original positions. It will not relieve the obliger from his liability, leaving him in possession of the fruits of the illegal transaction he complains of. I know of no case which cannot be explained upon this or analogous reasoning, and my opinion is that the court can never lawfully impose merely arbitrary conditions upon a plaintiff only because he stands in that position upon the record, but can only require him to give the defendant that which by the law of the court, independently of the mere position of the party on the record, is the right of the defendant in respect to the subject of the suit. A party, in short, does not, by becoming plaintiff in equity, give up any of his rights or submit those rights to the arbitrary disposition of the court. He submits only to give the defendant his rights in respect of the subject matter of the suit on condition of the plaintiff obtaining his own. Cases may perhaps be suggested in which a question never can arise except against the plaintiff, but as a general proposition, it may, I believe, be correctly stated that a plaintiff will never, in that character, be compelled to give a defendant anything but what the defendant might, as plaintiff in force, provided a cause of suit arose. Um, right.
I think that's good for that
Yeah, no, I
footnote.
mean, obviously this footnote does go on for
Yeah.
almost 3 pages. So, I mean,
Yeah.
really all it's doing is showing that regardless of what position you're in, if you're a plaintiff or you're a defendant, uh, the Court of Equity is going to do equity by equality, which means that each person, regardless of their position that they're in, are going to get justice.
Hmm. Yeah. Yeah, exactly. And that is we will see that illustrated in a Supreme Court decision later in the show. Um, but yeah, that's that first part was what I really wanted to emphasize there because that is going to be brought up, like I said, in one of the cases we're going to talk about later. Um, hold on. I was slacking. I didn't grab that whole footnote right there. Um, okay. So yeah, moving right along here. I encourage everybody to go read the rest of that footnote though, because there's a lot of spicy little tidbits in there. And but moving right along, I did want to hit yeah, let's hit this limitations and then I want to hit the equitable remedies part. So this is from section 399 of the same book, Equity Jurisprudence, Volume 1 by Pomeroy. And this is its limitations. Broad as the principle is in its operation, it must still be taken with reasonable limitations. It does not apply to every unconscientious act or inequitable conduct on the part of the plaintiff. The maxim considered as a general rule, controlling the administration of equitable relief in a particular controversy is confined to the misconduct in regard to, or at all events connected with, the matter in litigation, so that it has in some measure affected the equitable relation subsisting between two parties and arising out of a transaction. It does not extend to any misconduct, however gross, which is unconnected with the matter in litigation and with which opposite parties has no concern. When a court of equity is appealed to for relief, it will not go outside of the subject matter of the controversy and make its interference to depend upon the character and conduct of the moving party, in no way affecting the equitable right which he asserts against the defendant or the relief which he demands. And obviously, I wanted to bring this up because it's the limitations of the maxims, because obviously all of these maxims have their limitations, and we should know the boundaries of the game. And the thing about the limitations of this maxim is they are pretty much that's pretty much the same limitations of the last week's maxim. He who comes to equity must come with clean hands. Really, the only limitation in it is it has to pertain obviously to the subject matter of the litigation. And you can't do like I brought up the point last week about the concept and logic of poisoning the well. It's about the same time. You can't bring up, he did this 5 years ago, so therefore he has clean hands in this litigation.
Yeah, it's got to be directly connected, like if there's like, let's say between Dustin and I, we had some, argument over, I don't know, let's say like who actually owned a book, and we're in court over it, and I say, yeah, well, he doesn't have a case because he likes eating pineapple on his pepperoni or his pizza, and that's disgusting. So therefore, he should give me my book back. And the judge might say, well, no, you're right. That is absolutely disgusting, sir, but that has nothing to do with who owns the book. So the court is not going to take cognizance of that fact. And
Which
so it's like you might have dirty hands, might have pineapple and pizza sauce all over your hands, but it has nothing to do with whether or not you own the book. So they're not going to look at your dirty hands.
yeah, which just for the record, pineapple's fire on pizza. I'll just say.
Yeah, I just use that because most people are like, I mean, I like anchovies on
Oh,
pizza.
fuck.
What, you don't like that?
No, I can't do the
Oh,
anchovies.
I'll slurp those anchovies off the pizza
Oh,
first.
God. I had an ex that loved that shit. Oh.
Oh man, I'll you know what? You keep the pizza, just give me the anchovies actually.
No, nope, not me. You keep them anchovies off my
Okay, well, I'm
pizza.
gonna have dirty hands that smell like fish, but that doesn't mean I still don't own the book.
Give me the money. Give me the money. Yeah.
Yeah.
All right. Oh, that's hilarious. All right. We got about 15 minutes left. So I did bring up another section because this is relating to specific performance, which is we talked about that last week also. That was in one of the Supreme Court cases where the so obviously because these maxims do work so closely hand in hand, uh the it has a lot to do with specific performance and kind of like we talked about earlier, just basically giving notice, doing your what the contract actually said you were going to do, and doing it how the contract said you were going to do it. So I don't think we really need to rehash that one here because I wanted to get into another book of Pomeroy's, Equitable Remedies, Volume 1, because it is actually, could you look up the definition of laches? Laches. Um, and while he's doing that, I'm just gonna, well, oof, maybe we won't read this one into the record. I forgot how long this was. Um, is it here? This is where, right, okay. At the very end of it, it does get into, so I'm gonna read this beginning part where it kind of explains what latches are in a legal sense. This is section 21, Equitable Remedies, Volume 1, General Doctrine, Latches in Prejudicial Delay. The true doctrine concerning latches has never been more concisely and accurately stated than in the following language of an able living judge. Latches in legal significance is not mere delay, but delay that works a disadvantage to another. So long as parties are in the same condition, it matters little whether one possesses a right promptly or slowly within the limits allowed by law, but when knowing his rights, he takes no step to enforce them until the condition of the other party has, in good faith, become so changed that he cannot be restored in his former state. If the right be then enforced, delay becomes inequitable and operates as an estoppel against the assertion of the right. The disadvantage may come from loss or evidence, change of title, intervention of equities, and other causes. But when a court sees negligence on one side and injury thereon the other, it is ground for delay or relief. So yeah, that did you get the definition?
Yeah, definition of latches.
Yeah.
This word, derived from the French lacher, is nearly synonymous with negligence. In general, when a party has been guilty of laches in enforcing his right by great delay and lapse of time, this circumstance will at common law prejudice and sometimes operate in bar of a remedy, which it is discretionary and not compulsory in the court to afford. In courts of equity also delay will generally prejudice. And the cases there cited, it lists a couple there, but laches may be excused from ignorance of the party's rights, from the obscurity of the transaction, by the pendency of a suit, and where the party labors under a legal disability as insanity, coverture, infancy, and the like, and no laches can be imputed to the public.
Okay. Yeah.
Interesting. So, basically your rights will stale over time if you don't enforce them. And if the court of equity sees that you know that you had a right to enforce something and you just decided to sit around on it for a while, once you decide to enforce that, like if it's against a company or a corporation or another party, it's like by the time you come around to enforcing your rights, there might be other agreements. That property that you had a right to has been, moved or circumstances have changed. And by the very fact of you asserting your rights, you might actually cause inequity to a lot of other people. And so that's why, equity aids the vigilant, not those who slumber on their rights. That's another
Mm-hmm.
maxim.
Mm-hmm. Yeah. Yeah.
And so
Absolutely.
that's why a lot of times, especially on the at law or the civil side, they will try to attach latches to any of your claims or any of the things that you're trying to get done because they're trying to prove that, well, you waited too long, so sorry, so sorry.
Hmm. Yeah, yeah, absolutely. Yeah, I thought that was a very interesting point to bring up because I guess I didn't realize that was a legal strategy, I guess is what you would call it, as the case of latches, where you're basically you're trying to fuck up the timing of everything.
Yeah,
And
and but it also does say that no latches can be imputed to the public. So I'm thinking it's talking about the public jurisdiction. They can invoke their rights at any time, regardless of how long it's been.
mm,
Um, but what it also says that latches may be excused due to ignorance of the party's rights. So if you didn't know you had a right for 40 years to, let's say, change your status or to live or work differently, and you found out, if you can prove that you were ignorant of your rights for 40 years, they can't attach 40 years worth of latches saying that you just sat on it. Or if you were under a legal disability, like
mm.
insanity, coverture, which I think is a state of marriage, infancy, and the like. And again, the definition of infant is anybody who
Mm,
has not reached the age of 21 years old. And then if you don't declare yourself to be an adult, you will still be presumed to be an infant. And
hmm.
so, again, if you're still an infant ward when you're 35 years old and you figure it out and you change everything, you can basically say, okay, back to the time that I was not a ward or I should not have been, which is, 18. Um, I was basically ignorant. So
Hmm.
they'll excuse latches for that. It's like due to my ignorance is something that you would put in an averment or whatever else to
Well, and it
avoid.
would be nunc pro tunc ab initio, right?
Yeah, nunc pro tunc ab initio, all the way back to the beginning,
Yeah.
then as now, basically,
Yep. Then for now.
from
Yeah.
the beginning.
Yep.
Due
Then for
either
now
due
for
to
now.
my ignorance or due to obscurity or whatever it might be.
Mistake or what was the other one? Not fraud, mistake or dang it, what's the other word I was thinking of? Oh, I can't
You're not
remember.
thinking of waste, fraud, and abuse.
No, a mistake, fraud, and dang it, why can't I remember that
I
word?
thought I thought it was ignorance, but I know there's another one
Maybe
that
it
you
is
mean.
ignorance. Yeah, I think it's a different word I'm thinking of. Dang it, man, it slipped right out of
But
my
I
head.
mean, even in the definition of latches, it says that latches will be excused either due to infancy, which is a disability,
Yeah,
apparently, um,
right.
or ignorance. So it's okay, if you've lived your whole life a certain way and you finally realize that you have rights, all you have to do is you've got to declare that either due to your ignorance or that your current position that, you know, you were not aware or it was a
Hmm.
mistake by your parents, who registered your birth.
Yep. Yep. Yeah, a lot
You know,
mistake is a huge word in equity.
yep.
Huge word. Yeah, definitely everybody should look up the definition of mistake. But I did want, before we take off for this first hour, I did want to read this last little bit since we just read the definition of latches into the record. This last little bit of section 21 of equitable remedies. Every case is governed chiefly by its own circumstances. Dictated to substantially the same effect from nearly all American courts may be readily accumulated, all tending to show that the doctrine of lashes is for the most part merely an application of the broader maxim of equity. He who seeks equity must do equity, and he who comes into equity must come with clean hands. It, ex- it exacts of the plaintiff no more than fair dealings with his adversary. It is in no way dependent on those general considerations of the public unity and the repose of society, which are, in legal theory, the legislative motive for statutes of limitations. Interesting, which is kind of something we kind of just hit on. Statute of limitations, which doesn't exist in equity.
I'm gonna have to really look into that last thing, just the way that it's written.
Yeah.
It is in no way dependent on those general considerations of public utility and the repose of society, which are, in legal theory, the legislative motive for statutes of limitations. So
Yeah.
yeah, so really statutes of limitations is pretty much like they're manifesting laches already. They're saying, hey, if you've got a right, you have up to and including 2 years to say something.
Oh,
And
yeah. Yep.
so
That's
what it's
exactly what
saying
it
is
is.
basically um, that the maxim as used in equity is not dependent on the general considerations of public utility, legal theory, the legislative statutes of limitations. The statute of limitations, the legal theory of it, and the public utility of it draw from equity that maxim, and they basically codify what they're calling laches, but they're deciding what the time limit is
Mm.
for you to invoke your rights on something on the legislative side, the legal side.
That's interesting. Yeah, I
So it's
hadn't thought of it that way, but yeah, statutes of
because
limitations are
the
pretty
outlaw
much
side wouldn't make room for, hey, I was ignorant for 40 years. Hey, I was an infant. Hey, I this or hey, I that. The law basically says, sorry, statute of limitations says this, latches is basically applied at 2 years. Oh, you
yeah,
sat on it. Sorry. But in
yeah,
equity, they'll look at the intent, they'll look a little deeper, and they'll say, okay, we're going to decide to what degree, if any, latches are going to apply depending on your own particular circumstance.
yeah. How you acted, not how the statute was written.
Right. It's like, oh, you didn't realize you were an infant ward? Okay,
Yeah,
well, can you show me when it is that you found out?
right.
Okay, well, that's a lot more recent. I
Yep.
mean, okay, they're going to test you a little bit, throw some questions at you. It's like, okay, yep, you stated that you were ignorant, which is why you didn't invoke your rights. I found that you are now not ignorant. Okay, I see that you absolutely do have an equitable claim.
Hmm.
Let's go ahead and get you what you want. We'll do
Yeah.
equity, by equality and not by halves.
Right. Yeah, which is basically what we've been talking about this whole first hour. Um, yeah, so I think that's a great little spot to leave it right there. Um, and this was a good first hour, man. You got anything else you want to add before we get ready to head to the second hour and talk about some Supreme Court cases?
No, let's get into those cases. They're interesting because both sides that sometimes prove that they didn't play so nice or they got caught with their pants down.
Right. Yeah. Yeah, for sure. I'm excited for it. I hopefully we'll see everybody over there. If you want to listen to the second hour, you can go to the Learning Out Loud podcast.system.io. Catch the second hour there. You can download the transcripts, everything, the show notes that you see on screen right here. They're interactive show notes. You click on all this stuff, gets you right to it. And there's a whole bunch of other stuff over there. You can get to truelifeproductions.com. Go check it out. We hope to see everyone over on the second hour. And never forget to seek truth and honor the Creator above all, and let that be the whole of the law.
That's the important thing here, is that everyone's word should be meant for a use.
And the words that I'm using today are meant to pull down idols within people's temples.
Meaning that I want to destroy
Falsities that they have idolized.
for their entire life.
And just pull those out and sweep them clean. And before that temple,
And get reinfested with a new lie. Give it true life.